and our FY22 budget seeks the largest ever increase for the division, totaling more than 15%. We have appointed department-wide coordinators for our hate crimes work, and we have stepped up our support for the Community Relations Service and the department-wide efforts to advance environmental justice and tackle climate change. We are also revitalizing and expanding our work to ensure equal access to justice. In the days ahead, we look forward to working with Congress to restore a standalone Access to Justice office within the department dedicated to addressing the most urgent legal needs of communities across America. In addition to these core priorities, another important area of departmental focus is ensuring antitrust enforcement, reinvigorating that enforcement, combating fraud, and protecting consumers. We are aggressively enforcing our antitrust laws by challenging anti-competitive mergers and exclusionary conduct, and by prosecuting price fixing and allocation schemes that harm both consumers and workers. In FY22, we are seeking additional resources to reinvigorate antitrust enforcement across the board. We also stood up the COVID-19 Fraud Enforcement Task Force to bring to justice those who defrauded the government of federal dollars meant for the most vulnerable among us. In sum, in 7 months, the Justice Department has accomplished a lot of important work for the American people, and there is much more to be done. Thank you for the opportunity to testify today, and I look forward to your questions.
Thank you for your testimony. We will now proceed under the 5-minute rule with questions, and I will recognize myself to begin for 5 minutes. Mr. Attorney General, in the 2013 decision Shelby County versus Holder, the Supreme Court gutted Section 5 of the Voting Rights Act, rendering its pre-clearance provision inoperative. As a direct result of this decision, the right to vote has come under a renewed and steady assault, and states have spent the past 8 years enacting a slew of barriers to voting that target or impact communities of color and other historically disenfranchised groups. Before this committee in August, Assistant Attorney General Kristen Clark testified that, quote, Section 5 of the Voting Rights Act was truly the heart of the act and called it the department's most important tool for safeguarding voting rights in our country. Why is Section 5 pre-clearance so crucial to combating discriminatory voting practices?
Thank you, Mr. Chairman. Voting, the right to vote, is a fundamental aspect of our democracy. In many ways, it is the right from which all other rights occur. The Voting Rights Act was a gem of American legislation, as President Ronald Reagan said, and as all other presidents on both sides of the aisle have said. A key part of that provision was Section 5, as you said. This was a pre-clearance provision, which required in specified states where there had been discriminatory practices that provisions for changes in patterns or practices of voting should be submitted to the department for pre-clearance to determine whether they violated the act. There was another alternative. If a state did not like the result from the Justice Department, it could go to a court and get a resolution there. But the great idea of pre-clearance was to allow advance review before these things went into effect, rather than require the Justice Department on a one-by-one basis after the fact. It makes it extremely difficult to attack unlawful prescriptions on voting practices.
Thank you. Assistant Attorney General Clark testified that Section 2 is no substitute for the important swift preemptive review that was provided by way of Section 5 pre-clearance process. The full impact of the Supreme Court's recent decision in Brnovich versus DNC on Section 2 remains to be seen. However, in the absence of an operational Section 5 pre-clearance regime, what steps has the Justice Department taken to increase enforcement of voting rights under Section 2?
So, Section 2 is a remaining tool. It's extraordinarily important, and it does give us some impact. In order to better effectuate that provision, we have doubled the size of the voting rights section because it will take more people to evaluate state laws on a one-by-one basis. So we are going about doing that. We have brought one case, as you know, with respect to changes in Georgia. We are looking carefully at other states, and we are looking carefully at the redistricting, which is occurring as we speak now as a result of the decennial census. We continue to do that and vigorously make sure that Section 2 is appropriately enforced.
But if you should find that a given state's reapportionment, for example, was unconstitutional and you sued, it could take 6 or 8 years for those suits to be resolved, as we have seen, and that's one reason, another reason for the necessity for Section 5 preclearance. My time is short, so I have only one last question for you. The country and the Congress is still reeling from the events of January 6th, and the Select Committee is diligently pursuing its investigation into the insurrection. This week, Chairman Thompson and his colleagues voted to hold in contempt Steve Bannon, who failed to comply with the Select Committee subpoenas, and the measure will be taken up by the House later today. Unfortunately, the actions of individuals like Mr. Bannon are not new to us. Many committees, including this one, repeatedly faced obstruction from the prior administration and the former president's loyal allies. Congress, however, is not an enforcement body and looks to the department to handle criminal matters when appropriate. So I ask you, Mr. Attorney General, regardless of politics, will the department follow the facts and the law and expeditiously consider the referrals put forth by the Select Committee if and when they are approved by the full House?
So the department recognizes the important oversight role that this committee, the House of Representatives, and the Senate play with respect to the executive branch. I will say what a spokesperson for the U.S. Attorney's Office in the District of Columbia said, I think yesterday or the day before. The House of Representatives votes for referral of a contempt charge. The Department of Justice will do what it always does in such circumstances. It will apply the facts and the law and make a decision consistent with the principles of prosecution.
Thank you very much.
Pull the mic a little closer, Mr. Attorney.
Oh, I'm sorry. Is that better?
Mr. Shabbat?
Sure, of course.
Yeah, Mr. Shabbat.
Thank you. Mr. Chairman, I'd start by asking unanimous consent that an op-ed that appeared in last week's Wall Street Journal by the author of the Patriot Act, Mr. Sensenbrenner, former chairman of this committee, entitled "The Patriot Act Wasn't Meant to Target Parents," be entered into the record.
Without objection.
Thank you. Mr. Attorney General, most of us had other jobs before we got here to Congress. For example, I practiced law for quite a few years. I was a county commissioner. I was a member of Cincinnati City Council. And before that, I was a school teacher in Cincinnati in the inner city. All the students in the school were African American, and I taught the 7th and 8th grade. It was my experience that the kids who did the best were the ones who had parental involvement in their education. Does that make sense to you?
Yes, I think parental involvement is very important in education.
Thank you. Now, with that in mind, having parents involved in their children's education, I have to say I found it deeply disturbing that the National School Board Association convinced the Biden administration to sic you and your Justice Department, the FBI, the full power of the federal law enforcement in this country on involved parents, as if they were domestic terrorists. One of the tools in your arsenal of weapons, of course, is the Patriot Act that I just mentioned. Not many current members of this committee were here when we passed the Patriot Act, but I was. And Mr. Chairman, you were too. And I remember clearly that we were both concerned about potential abuse of this new law enforcement tool. And that's why, for example, we insisted on sunset provisions on some aspects of the Patriot Act. But I can tell you, not in a million years did we dream that one day we'd see the Justice Department treat American parents as domestic terrorists. And in a primer on domestic terrorism issued last November by none other than the FBI, Mr. Attorney General, the FBI explicitly stated that, quote, under FBI policy and federal law, no investigative activity related to domestic terrorism may be initiated based on First Amendment activity, unquote. Now, parents speaking up at a school board meeting against the teaching of critical race theory or anything else that they want to talk about is clearly a First Amendment activity. Now, of course, school board meetings can sometimes be highly emotional affairs. Parents do care about their kids' education, how they're being taught, what they're being taught. And these parents have every right to be heard, even if former Virginia Governor Terry McAuliffe thinks otherwise. Now, no one has the right to be violent or threaten violence. And if anyone does that, they can be dealt with by security or by local law enforcement. But we don't need the vast power of the federal government throwing its weight around. We don't need you, your Justice Department, or the FBI trampling on the rights of American parents who just want the best possible education for their children. So, Mr. Attorney General, let me ask you this. According to the Sarasota Herald Tribune, one example of a so-called terrorist incident was a parent merely questioning whether school board members had earned their high school diplomas. Now, that might have been rude, but does that seem like an act of domestic terrorism that you or your Justice Department ought to be investigating?
Absolutely not, and I want to be clear. The Justice Department supports and defends the First Amendment right of parents to complain as vociferously as they wish about the education of their children, about the curriculum taught in the schools. That is not what the memorandum is about at all, nor does it use the words domestic terrorism or Patriot Act. Like you, I can't imagine any circumstance in which the Patriot Act would be used in the circumstances of parents complaining about their children, nor can I imagine a circumstance where they would be labeled as domestic terrorism.
Thank you. I'm nearly out of time, so let me just conclude with this. We ought to be encouraging parents to be actively involved in the education of their children. After all, if our children are to be competitive with the children of Japan and South Korea and India and, yes, China, for tomorrow's jobs, they better be getting a top-notch education in this country. Let's support and welcome parental involvement, not use the vast powers of federal law enforcement to target parents as domestic terrorists. And I yield back.
The gentleman yields back. Once again, I would remind all members that guidance from the Office of Attending Physician states that face coverings are required for all meetings in an enclosed space, such as committee hearings, except when you are recognized to speak. And that means you, Jim, and Marjorie, and Matt, and a lot of other people I can't recognize because of distance, et cetera. So please, everyone, observe that rule. I'll now recognize Ms. Lofgren for 5 minutes.
Thank you, Mr. Chairman, and thank you, Mr. Attorney General, for being here this morning. At your confirmation hearing, you characterized what happened on January 6th as, quote, a heinous attack that sought to disrupt a cornerstone of our democracy. I agree with that. And in your written testimony today, you point out that the intelligence community has identified domestic violent extremists as the primary threat to our nation, and further note that your department is committed to keeping our country safe by protecting our democratic institutions. I would note that protecting our democratic institutions is not limited to the Department of Justice. The Congress also has that obligation to protect our democracy. To that end, we have a select committee that is reviewing the events leading up to January 6th and has a legislative mandate to devise legislative recommendations to prevent future acts of domestic extremist violence, to strengthen the resiliency of our nation's democratic institutions, to propose laws that will keep our democratic systems safer. Now, with that background in mind, we are, as you're aware, seeking information to inform us to perform that role. Before you were AG, you were a judge, and I note that in your judicial role, in 2004, there was a case, Judicial Watch versus the Department of Justice, where the court ruled, quote, presidential communications privilege applies only to documents solicited and received by the president or his immediate White House advisors who have broad and significant responsibility for investigating and formulating the advice to be given to the president. I think you're familiar with that case. Do you think that's still good law?
Yeah, I think the D.C. Circuit is a good source of law.
In the Supreme Court case Nixon versus administrator of GSA in 1974, the Judicial Watch case actually relied on that precedent. That case said that the communications to advise the president would be only on official government matters. Do you think that's still good law?
I think the Supreme Court's opinion is still good law until it's reversed, when I see no sign that it's going to be reversed.
We were here in the Judiciary Committee pursuing testimony from Mr. McGahn, and the court wrote in the 2019 case, and this is a quote, "To make the point as plain as possible, it is clear to this court for the reasons explained above that with respect to senior level aides, absolute immunity from compelled congressional process simply does not exist." Do you think that's still good law?
I believe the McGahn case is still good law.
Recently, the Department of Justice informed a federal district court that, quote, "conspiring to prevent the lawful certification of the 2020 election and to injure members of Congress and inciting the riot at the Capitol, quote, would plainly fall outside the scope of employment of an officer or employee of the United States of America." Since your department filed that, I assume you agree with that.
Yes.
So I just want to mention, I'm not going to ask you about what your department will do if the House of Representatives adopts a referral to your department, because I take you at your word that you will follow the precedent, you will follow the law in the ordinary course of events. I would just note that your defense of the rule of law for the Department of Justice and your standing for the rule of law also means the rule of law for the Congress of the United States. Article 1 was the first article for a reason. We have a role to play in making sure that our democratic institutions are defended. I thank you for your service to our country, and I look forward to your deliberations so that the Congress of the United States can play its rightful role in defending our institutions and adopting legislation that will strengthen our institutions and preserve and protect our democratic republic. With that, Mr. Chairman, I yield back.
The gentlelady yields back. Mr. Gomert.
Thank you, Mr. Chairman, and thank you, Judge Garland, for being here. You stated a moment ago you couldn't imagine a parent being labeled a domestic terrorist, but parents all over the country believe that's exactly what you labeled them by your memo indicating you were going to get involved in board meetings, school board meetings, because of the threat of domestic terrorism. So if you can't imagine a parent being labeled a domestic terrorist, I would encourage you to redo your memo so it's not so perceived as being so threatening to people concerned about their kids' education. But I want to take you to January 6th. It's a very common topic here for people. Has any defendant involved in the January 6 events been charged with insurrection?
I don't believe so.
Well, that is the word most used by Democrats here on Capitol Hill about January 6, but no one has been charged with it that we could find either. How many protesters on January 6 were charged with obstructing an official proceeding for 4 to 6 hours? Do you know?
I don't know the exact number. Obviously, there are 650 who were arrested, some for assaulting officers, some for obstructing proceedings, some for conspiring to obstruct proceedings. I can get you the numbers for each of the specific.
Well, thank you. I'd be interested in getting that number. But regarding the men who broke the glass in the two doors there at the speaker's lobby when the two Capitol Police have been standing there, moved to the side to allow them access, were any of those people who broke glass and did damage to those doors working for the FBI or other federal law enforcement entities?
And this is an ongoing criminal investigation, and I'm really not at liberty to discuss. There have been some filings in a nature of discovery, which has been provided to the defendants, but other than that, I can't discuss this now.
Well, we've seen some of those filings that talk about persons 1 through 20-something. Were those persons 1 designated by number, were those people that were employed by the FBI or federal entities, or were they confidential informants?
Again, I don't know those specifics, but I do not believe that any of the people you're mentioning charged in the indictment were either one.
Was a determination ever made as to who repeatedly struck Roseanne Boylan in the head with a rod before she died?
Again, I think this was a matter that was investigated by the U.S. Attorney's Office, and
Well, there's a witness on video saying that it was a D.C. Metro policeman. I didn't know if you'd been able to confirm or deny that. Well, on June 22nd of 2016, Judge, most of the Democrat members of Congress took over the House floor, and for the first time in American history, members of Congress obstructed official proceedings, not for 4 to 6 hours, but for virtually 26 hours, not just violating over a dozen House rules, but actually committing the felony that some of the January 6 people are charged with. That was during the Obama administration. Nobody has been charged. And those kind of things where you let Democrat members of Congress off for the very thing that you're viciously going after people that were protesting on January 6th gives people the indication that there is a two-tiered justice system here in America. You know well, you've been a circuit court judge, you know well that confinement, pretrial confinement, is not ever to be used as punishment. Yet there are people, and understand, as a former tough law and order judge, I would sentence everyone, regardless of their party, who did violence or committed crimes on January 6th to appropriate sentences. But for heaven's sake, they are being abused in the D.C. jail. Have you done an inspection over there of the D.C. jail since your department has some jurisdiction?
so my understanding is Judge Lamberth, who I respect very much, has
Yeah, he held the warden in contempt, but we haven't seen the improvement.
He asked for a review, and the Justice Department is conducting a review. The marshals did an inspection the other day, which was reported in the news, and the Civil Rights Division is examining the circumstances. This is the District of Columbia Jail. It's not a Bureau of Prisons, you understand.
Time of the gentleman has expired. As I've explained to members on many occasions, I view the wearing of face masks as a safety issue, and therefore is an important matter of order and decorum. Because I am responsible for preserving order and decorum in this committee, I am requiring members and staff attending this hearing to wear face masks. I came to this decision after the Office of the Attending Physician released its guidance requiring masks in committee hearings some time ago. I note that some members are still not wearing masks. The requirement is that members wear their masks at all times when they are not speaking. I will take members in compliance with this rule into consideration when they seek recognition. I see Mr. Roy, for example. I now recognize Ms. Jackson-Lee.
Thank you, Mr. Chairman. General, let me thank you for your enormous work that the department is doing. I have a series of questions. Help me out and in your answers so that I can secure responses. As you well know, the Senate Judiciary Committee did an outstanding report on how the former president and his allies pressured DOJ to overturn the 2020 election. In particular, they noted a series of dates in which they assessed that the former president grossly abused the power of the presidency. He also arguably violated the criminal provisions of the Hatch Act, which prevents any person from commanding federal government employees to engage in political activity. Would there be any reason that the DOJ would not further research or determine prospectively that the former president could be prosecuted under the Hatch Act?
Congressman, the Justice Department has a very long-standing policy of not commenting on potential investigations or actual or pending investigations. This is a foundational element of our rule of law and norms. It's to protect everyone, no matter what their position, former president, current president, congresswoman, senator, or ordinary citizen. And I'm going to have to rest on that I can't comment on.
Thank you. I take that there's no prohibition, but thank you so very much. The Justice Department investigated Texas, 5 secure juvenile facilities, finding sexual abuse. Can I quickly get an answer of working with the Justice Department, encouraging standardized conditions for these facilities, since the facts were gross in terms of the abuse of those children? I think you're investigating Georgia as well. Mr. General?
So we are investigating Texas, and that was announced, and I believe the governor welcomed that investigation, and that's being done by a combination of the Civil Rights Division and all 4 U.S. attorneys' offices in Texas.
Thank you, sir. With respect to compassionate release, which came about through the CARES Act, we found that in the BOP, 39% of Americans in federal prison contracted COVID-19. 2,000, according to a New York Times article, 2,700 prisoners have died. There is a potential of the compassionate release being eliminated and those out, but also I found that it's not being utilized appropriately now. The Inspector General said that BOP was not prepared with the issue, was not prepared to deal with the issue of compassionate release on a granular level. And of course, the director himself said prisons are not made for social distancing. My question is, will you monitor what is going on with compassionate release, either in terms of people returning and or the utilization, the fair utilization of compassionate release in the BOP under this issue of COVID?
Yes, Congressman, the answer is yes. Obviously, the pandemic was not something that the Bureau of Prisons was prepared for, or frankly, most American institutions were not prepared for. It created a lot of difficulties. It did lead to compassionate release, leaving people in home confinement. I don't know the specifics that you're mentioning, but we are certainly reviewing carefully how the Bureau is responding now to this dangerous circumstance of COVID-19.
Thank you, General. We found, as it relates to the women in prison, 6,600 are serving huge sentences of life with parole, life with parole, life without parole, virtual life, etc. 86% of women in jail have experienced sexual violence, 77% have experienced intimate partner violence. This has given a report as it relates to women of color. Can we have a more vigorous trauma, mental health protocol for women in prison?
So I think, federal, yeah. So I think an important part of the First Step Act requires us to be careful about those things, and we've asked for additional funding for that purpose. And Deputy Attorney General is monitoring the way in which the Bureau of Prisons spends that money and establishes those programs.
Thank you. Can I quickly ask, with VAWA, which has not been passed by the House, would that passage help you do even a more effective job dealing with violence against women, like domestic violence, which is Domestic Violence Awareness Month this month? Would it help you be more effective in prosecuting and moving forward?
Yes, it would. We are strongly supportive of reauthorization of the Violence Against Women Act.
I'm going to make just a few statements. Gun violence in children has accelerated in a 19-year high in 2017. I would appreciate talking further about greater prosecution on gun trafficking and the proliferation of guns. Secondarily, hate crimes has surged as well, and we want to hear about the resources that are being used for hate crimes. And then, as you well know, that we have been the poster child in Texas for racial gerrymandering, and let me thank you for the work you've done under Section 2. Just want to make sure that this is on the radar screen of the Justice Department dealing with that issue of redistricting. But my question finally is, again, the Texas abortion law, one of the worst components is the stalking of women.
Gentlelady's time has
and so
expired.
I'm asking whether or not...
Gentlelady's time has expired. Mr. Owens.
Thank you, Mr. Chairman, and thank you, Attorney General Garland, for coming before our committee today. I'd like to take every opportunity that I have to share with our nation the making of a great community. I grew up in one in the Deep South 1960s. Though in the depths of Jim Crow segregation, it was community that produced giant Americans like Clarence Thomas, Condoleezza Rice, Thomas Sowell, Walter Williams, and Colin Powell. This was not by accident, it was not, and it was also not rare. It was a community of faith, family, free market, and education. Education was the very core of our success. I was raised in a home of teachers. My dad was a college professor for 40 years. My mom, a junior high school teacher. They were trusted to do what teachers have done throughout our history, to teach children how to read, write, add, subtract, and to think critically. Success in education was always based on parental involvement. It was both expected and welcomed. In my great state of Utah, these expectations of parents have not changed. We do not expect, nor will we tolerate, leftist teaching of our children behind our backs, the evil of CRT, how to hate our country and hate others based on skin color. Some of the most recent actions that the Department of Justice have taken against parents are concerning, and I'd like to direct my questions around that topic. Similar questions have been asked, and I do want to make sure, make it very clear that to some of my constituents, some of the concerns I have. We can all agree that true threats and violence at school board meetings are inexcusable. Attorney General Garland, do you agree with the National School Board Association that parents who attend school board meetings and speak passionately against the inclusion of divisive programs like critical race theory should be characterized as domestic terrorists?
I do not believe that parents who testify, speak, argue with, complain about school boards and schools should be classified as domestic terrorists or any kind of criminals. Parents have been complaining about the education of their children and about school boards since there were such things as school boards and public education. This is totally protected by the First Amendment. I take your point that true threats of violence are not protected by the First Amendment. Those are the things we're worried about here.
Okay, could I just
Those are the only things we're worried about here.
Okay, thank you so much for that. Is there legal precedent for the Department of Justice to investigate peaceful protests or parental involvement at public school meetings?
Just to say again, we are not investigating peaceful protest or parent involvement in school board meetings. There's no precedent for doing that, and we would never do that. We are only concerned about violence, threats of violence against school administrators, teachers, staff, people like your mother, a teacher. That is what we're worried about. We are worried about that across the board. We're worried about threats against members of Congress. We're worried about threats against police.
Thank you very much. Thank you very much for that. I'm also a member of the Education and Labor Committee. On October 7th, Republican members of this committee sent you a letter, you and Secretary Cardona, expressing a concern about disparaging remarks that the Secretary had made against parents. In this letter, we request that you brief the Education and Labor Committee before taking action on your threats to parents' lawful expression of legitimate concerns. Have you received that letter, and do you plan on testifying before the House Education and Labor Committee?
I'm sorry I don't recollect the letter, but I'll ask my staff to find out where it is.
Okay. Let me just say this as I wrap this up, and I do appreciate you being here, Attorney General. I watched a time, I was aware of a time when our race led our country in a percentage of men matriculating from college, black men matriculating from college. I now have been aware of in 2017 studies that Department of Education, that 75% of the black boys in the state of California cannot pass standard reading and writing tests. That's a big shift. And the difference is, in those days when I was growing up, parents were involved. There was a trust that we can send our kids to school and they'll be taught how to love our country, love each other, and love education. That has been changed drastically. And I think I'm going to implore parents out there, get involved. Now's the time. Do not trust any other adults, particularly our educational system, for the future of your kids. Get involved. Fight for your rights, for your kids to be taught how to love our country, love education, and move forward. And I think we do that, we get back to the old school America where we can really appreciate the fact of who we are and the education system that should be teaching us how to do that. I yield back my time.
Gentleman yields back. Mr. Cohen.
Thank you, Mr. Chair. Welcome, General Garland. I feel it's a difficult position for me to question you because I have such respect for your acumen, your probity, and your rectitude, which is widely recognized, but there are questions I must ask. The Senate Judiciary Committee had a report recently about the attempts of President Trump to get Department of Justice employees involved in the Stop the Steal campaign, trying to subvert the election. Are any of those people that were involved in that still at the Justice Department?
You know, all the bold-faced names that I know about were political appointees, all of whom are not at the department. I don't know the answer otherwise, but I don't believe so. But
Thank you. I would appreciate if you'd check into that. If they were and they participated in this in any way, that they should come to your attention and they should have certain sanctions, I believe. You have defended and sought to continue to defend President Trump in his defamation action brought by E. Jean Carroll. He called her a liar. He accused her of conspiring with the Democratic Party in her allegation of rape. And for what it was worth, he said she wasn't his type. His type is apparently fairly expansive. And you're defending him. Do you think that the public sees that as a proper use of Department of Justice resources when it's been shown that we're short on personnel in the Civil Rights Division and that we need that personnel, and yet we're defending President Trump's defamation lawsuit by a woman who he has defamed?
Congressman, we are not defending the defamation made by the former president. As I've said publicly several times, sometimes being the Attorney General and sometimes being the judge means taking positions with respect to the law that are required by the law, but which you would not take as a private citizen. In this circumstance, the Justice Department's briefing is not about whether this was defamation or wasn't defamation. It was solely on the question on the application of the Tort Claims Act. And there is consistent precedent in the D.C. Circuit which holds that even defamatory statements made during press conferences by public officials are within the scope of employment for that very narrow purpose and for that very narrow definition.
If I may, sir, and I appreciate that and I've read that, but this was an action he took as a private citizen. He is now again a private citizen, and it was totally outside of anything to do with him being president. I hope you will look into it again, because I think the public sees it as a mistake. The rule of law, you made clear, and I know you believe this, is one of the major tenets of the Department of Justice to uphold the rule of law. Michael Cohen has a felony on his record, spent time in prison for paying, at the direction of President Trump, hush money to Stormy Daniels and another woman. I believe that it's pretty well known that President Trump was individual one, as described in the indictment. He couldn't be indicted because of Department of Justice policy. You don't indict a sitting president. He's no longer a sitting president. Do you believe that not looking into indicting individual one, equally, if not more guilty than Michael Cohen, is not an abuse of equal protection under the law and an abrogation of the idea that the rule of law is principle?
So, Congressman, and a very important element of the rule of law is the norm of the Justice Department that we don't comment on whether we're investigating, what the status of investigations are, unless and until there's a public charge. That's important to protect everyone, whether it be a former president, an existing president, or a public official or a private individual.
I will accept that, but I hope that you will look at it, because I believe that he is equally, if not more guilty, and it does seem that people get favored treatment if he's not prosecuted. Transparency is important as well. Amy Berman Jackson tried to release some records concerning Bill Barr's downplaying of Trump's obstruction and the Mueller investigation. This committee was looking into the Emoluments Clause violations of the Trump Hotel and got an order to see some records, and yet the DOJ appealed. Do you believe that transparency, those two situations are ones where transparency was not permitted to the American public, as well as the whole Mueller report, which hasn't been redacted?
Well, with respect to Judge Jackson's ruling, I respect Judge Jackson. She was a former colleague. I respect her very much. We just have a difference of opinion with respect to the Freedom of Information Act deliberative privilege exception. And we believe that in that circumstance, the memorandum which was given to Attorney General Barr is protected by that, so that all attorneys general can receive honest advice from their subordinates. That matter is before the D.C. Circuit now. Everything I've just said is in our papers, so I'm not saying anything outside the record, and it will be resolved by the D.C. Circuit.
Thank you.
Gentleman's time
I
is
yield back the
expired.
balance of my
Mr.
time, but I
Johnson of
thank you.
Louisiana.
Thank you. Mr. Attorney General, millions of Americans are deeply concerned today that instead of addressing the most pressing issues facing our country, we're watching the Biden-Garland Justice Department be weaponized, that you are using your authorities now to advance far-left policies and attack Republican-led state actions and erode constitutional norms. The most recent case in point has been brought up this morning. Your memorandum directing the FBI and other Department of Justice officials to get involved in local school board debates. It concerns us that it was issued just 5 days after the National School Board Association sent a letter to President Biden which referred to concerned parents as the equivalent of, quote, domestic terrorists and perpetrators of hate crimes, unquote. Given the timing of all this, your memo appears to have been motivated by politics more than any pressing federal law enforcement need. This is concerning to us, and it's worthy of investigation. It also concerns us that your actions may have been motivated by your family's financial stake in this issue. Published reports show that your son-in-law co-founded a company called Panorama Education. We now know that that company publishes and sells critical race theory and so-called anti-racism materials to schools across the country. And it works with school districts nationwide to obtain and analyze data on students, often without parental consent. On its website, the company brags that it's surveyed more than 13 million students in the U.S. It's raised $76 million from powerful investors, including people like Mark Zuckerberg, just since 2017. My first question is this: are you familiar with Title V of the Code of Federal Regulations, which addresses the rules of impartiality for executive branch employees and officials?
I am very familiar with it, and I want to be clear once again that there's nothing in this memorandum which has any effect on the kinds of curriculums that are taught or the ability of parents to complain about the kinds of...
I understand your position on the free speech of parents.
Position, it is
Wait just a minute. The question is, the thing that has concerned many of those parents that are showing up at these school board meetings, the very basis of their objection and their vigorous debate, as you mentioned earlier, is the curricula, the very curricula that your son-in-law is selling. So to millions of Americans, I mean, my constituents, I was home all weekend, I got an earful about this. They're very concerned about that. Subpart E of that federal regulation says an employee of the executive branch is discouraged from engaging in conduct that's likely to affect the financial interest of someone close to them. Your son-in-law, your daughter, clearly meets that definition. And so the question is, did you follow that regulation? Did you have the appropriate agency ethic official look into this? Did you seek guidance as the federal regulation requires?
This memorandum is aimed at violence and threats of violence.
Understand that, but did you seek ethics counsel before you issued a letter that directly relates to the financial interest of your family? Yes or no?
This memorandum does not relate to the financial interests of anyone. It's against...
I take that as a no.
Memorandum is against violence and threats of violence.
Will you, Mr. Attorney General, will you commit to having the appropriate ethics designee review the case and make the results public?
This memorandum is aimed at violence and threats of violence.
I understand your talking point. You're not answering my question, Mr. Attorney General. With all due respect, will you submit to an ethics review of this matter, yes or no?
There's no company in America, or hopefully no law-abiding citizen in America, who believes that threats of violence should not be prevented. There are no conflicts of interest that anyone could have.
According to you, but sir, with due respect, that's the purpose of the federal regulation. We need objective third parties to review our activities. You don't get to make that decision yourself. It doesn't matter. You're the chief law enforcement of this country. This raises questions in the minds of millions of Americans, and your impartiality is being called into question. Why would you not submit to a simple ethics review of that?
I am exquisitely aware of the ethics requirements.
But you're not following them.
I have followed them and lived with them for the last 25 years.
Did you seek an ethics review of this or not?
I'm going to say again, there are no conflicts of interest involved when the Justice Department...
Okay. According to you, I got that. I'm not trying to be disrespectful, but you are not respecting our rules, our constitutional norms, and the federal law that directly applies to your activities. This is a great concern. This is why people are losing faith in our institutions. They're losing faith in this Department of Justice. And you and I both know, as constitutional attorneys, that if the people lose their faith in our system of justice, if they lose their faith in the idea that justice is blind, that there are not two standards, that there's one standard of the law, and that everybody...
Time of the gentleman has expired. Would the Attorney General like to respond to the innuendo?
No, all I can say is I completely agree that the rule of law and respect for it is essential. And I will always do everything possible to uphold that and to avoid any kind of conflict of interest.
But you will not submit to an ethics
Time of
inquiry.
the gentleman has expired.
I would just point out,
Time of the gentleman has
it wasn't innuendo, it was a question.
Thank you.
It was a question.
Question is
And the
that of
editorial
time?
comments from the chair about
Air-
other
the-
people's questions is not
the
appreciated by
Attorney
this side of the
General.
aisle.
Mr. Johnson of Georgia.
Thank you, Mr. Chairman, and thank you for being here, General Garland. This summer, the House passed H.R. 4, the John R. Lewis Voting Rights Advancement Act, which would strengthen Sections 2 and 5 of the Voting Rights Act. And also this summer, the department announced that it was suing the state of Georgia under Section 2 of the Voting Rights Act. And I commend your department for working to protect the rights of all Americans to vote. General Garland, Section 2 of the Voting Rights Act prohibits voting practices or procedures that discriminate on the basis of race, while Section 5 of the Act mandates that changes to voting practices in certain covered jurisdictions be pre-cleared by federal authorities. With the Supreme Court having nullified Section 5, in effect, the pre-clearance requirement by ruling that the coverage formula was unconstitutional, does the department view Section 2, litigation alone, as adequate to safeguard voting rights, or must Congress pass the John Lewis Voting Rights Advancement Act and reinstate Section 5 in order for voting rights to be adequately safeguarded?
The Justice Department supports that act. Section 2 is what we have. Section 5 is what we need.
Knowing that the House has already passed H.R. 4, does the Justice Department support passage of the John Lewis Voting Rights Advancement Act in the United States Senate?
Yes, sir.
Thank you. On September the 4th, 2021, DOJ announced an investigation into Georgia prison conditions. The New York Times reported that over 25 incarcerated persons died last year by confirmed or suspected homicide in Georgia prisons, and 18 homicides, as well as numerous stabbings and beatings, have been reported this year. What is the timeline for this investigation, and will you commit to briefing the committee and the Georgia delegation on the results of the inquiry?
We are doing that investigation. It's pursuant to a statute which authorizes the Civil Rights Division to bring those kinds of cases. I can't tell you what the timeline is. These kind of things take a considerable amount of time. And I'm not sure what the legal requirements are with respect to briefings outside. This is now in court, and so I'm not sure what additional material can be provided outside of what we provide in court, but we'll look into it for you.
Thank you. Much of what is known about conditions in Georgia prisons is derived from social media posts, including video footage posted during a prison riot last year. How are social media and the use of smuggled smartphones by inmates aiding DOJ in its civil rights investigation of Georgia's prisons?
Sorry, I don't know the answer to that question, but I'll see if I can ask at the Civil Rights Division how they're using that material.
All right, thank you. Mr. Attorney, Mr. General Garland, the Sackler family has used every trick in the book to escape accountability for their role in the opioid epidemic, including abusing the bankruptcy system to secure civil immunity from their victims. And now Johnson & Johnson has scrambled its organizational charts to put tens of thousands of legal claims into bankruptcy to avoid further liability for its cancer-causing talcum powder. Do you believe culpable individuals and corporations should be allowed to use the shell game to shield themselves from liability?
I don't know anything about the second example that you gave. As to the first, the Justice Department's bankruptcy trustee has weighed in to appeal the decision to immunize from personal liability, and I think that matter is now pending in court.
Thank you. Lastly, I will note that there's been a lot of discussion by my friends on the other side of the aisle about local school boards, and I will point out the fact that there are reports that restrictions on the discussion of race and history in schools, these laws that are being put forward by Republican-led states, are causing administrators to tell teachers that in addition to having an opposing view on slavery, now they are saying that you've got to include an opposing view on the Holocaust. If you have any books that are teaching about that, you've got to have an opposing view. This is the danger that we...
The gentleman's time has expired. Mr. Jordan.
Thank you, Mr. Chairman. March 25th, Joe Biden criticizes the Georgia election law. 3 months later, the Department of Justice challenges it. September 1st, Joe Biden criticizes the new pro-life law in Texas. 8 days later, the Department of Justice challenges it. September 29th, the political organization asked President Biden to involve the FBI in local school board issues. 5 days later, the Department of Justice does just that. Mr. Attorney General, was it just a coincidence that your memo came 5 days after the National School Boards Association letter went to the president?
So we are concerned about violence and threats of violence across the board against school officials, against...
Is there any connection, Mr. Attorney General, with the school board letter and then 5 days later your memo to regarding school board issues?
Obviously, the letter, which was public and asked for assistance from the Justice Department, was brought to our attention, and it's a relevant factor in...
Who gave you the letter?
I'm sorry?
How'd you become aware of the letter? Who gave it to you?
I read about the letter in the news. That's how I read about it.
What the White House told you to write the memo?
No one in the White House spoke to me about the memo at all, but I am sure, at least I certainly would believe that the White House communicated its concerns about the letter to the Justice Department, and that is
Oh, that was my next question. Did you or anyone at the Justice Department discuss the memo with White House personnel or with anyone at the White House before the memo was sent?
I did not. I don't know whether anyone discussed the memo. I am sure that the communication from the National Association of School Boards was discussed between the White House and the Justice Department, and that's perfectly appropriate, just as...
Who were those individuals? Who at the White House talked with who at the Justice
I
Department?
don't know. I don't know.
Did they talk to you? Did someone call you?
I think I've answered. No one from the White House spoke to me, but the White House is perfectly appropriately concerned about violence, just like they're concerned about violence in the streets, and they make requests of the Justice Department in that respect, just like they're concerned
Did
about...
you or anyone at the Department of Justice communicate with the American Federation of Teachers, the National Education Association, and the National School Boards Association prior to your memo?
I did not. I don't know.
Don't know if anyone else at the Justice Department did?
I don't know.
You know, did you or anyone at the Justice Department communicate with those organizations, AFT, NEA, National School Board Association, prior to the letter? Did you help the National School Board Association put together the letter?
Again, not. I have had no such conversations. I would be surprised if that happened, but I don't know.
Will FBI agents be attending local school board meetings?
No, FBI agents will not be attending local school boards meetings, and there's nothing in this memo to suggest that. I want to, again, try to be clear. This memo is about violence and threats of violence.
Let me just point out, the same day you did the memo, the Justice Department sent out a press release, Monday, October 4th, 2021. The press release says, Justice Department addresses violent threats against school officials and teachers. Now, you said earlier to a question from one of my colleagues on the Republican sides that parents aren't domestic terrorists, we're not going to treat them that way. But let me just read from the third paragraph. According to the Attorney General's memorandum, the Justice Department will launch a series of additional efforts in the coming days designed to address the rising criminal conduct directed towards school personnel. Those efforts are expected to include a creation of a task force consisting of representatives from the Department's Criminal Division, Civil Rights Division, Executive Office of U.S. Attorneys, the FBI, the Community Relations Service, Office of Justice Programs, and the National Security Division. Now, I find that interesting. You said there's no way you're going to be treating parents as domestic terrorists, but you got the National Security Division in a press release regarding your memo that day.
My memo does not mention the National Security Division. It's addressed
I
to...
didn't say it did. I said the press release accompanying your memo that day from the Department of Justice, right here it is,
I'm gonna be as clear
talks
as
about
I
the
can
National
be.
Security
This
Division
is
being
not-
part of this effort.
I want to be clear as I can be. This is not about what happens inside school board meetings. It's only about threats of violence and violence aimed at school officials, school employees, and teachers.
First sentence of your
Respect
memo,
the
very first sentence, you said, in recent months, there's been a disturbing spike in harassment, intimidation, threats of violence.
Yes.
When did you first review the data showing this so-called disturbing uptick?
So I read the letter, and we have been seeing over time threats.
Whoa. I didn't ask you. So you read the letter, that's your source?
So let me be clear. This is not a prosecution or an
Is there some
investigation.
study, some effort, some investigation someone did that said there's been a disturbing uptick, or you just take the words of the National School Board Association?
When the National School Board Association, which represents thousands of school boards and school board members, says that there are these kind of threats, when we read in the newspapers reports of threats of violence, when that is in the context of threats of violence
The
against
source
all-
for this, for the very first line in your memo.
Time of the gentleman has
disturbing spike
expired.
Was the School
The
Boards
time of the gentleman has
Association
been
letter.
expired. Mr. Deutsch.
Thank you, Mr. Chairman. Thank you, General Garland, for being here. What's so disturbing to me is a lack of concern about threats of violence. General Garland, let me give you some examples. In Brevard County, Florida, a school board member reported she was followed to her car, received messages from people saying, "We are coming for you," and begged for mercy. She was concerned when people were going behind her home and brandishing weapons. She's not alone, Attorney General. In Texas, a parent tore a teacher's mask from her face. In California, a parent verbally assaulted a principal and physically attacked a teacher who intervened, sending him to the hospital. In Arizona, a school official was told, "You're going to get knifed." A fist fight broke out after a school board meeting in Missouri. I appreciate, Attorney General Garland, your concern about threats to people who are doing their job trying to help our kids get a good education. I'm grateful to you for that. My question is that as our governor in Florida claimed that your efforts are weaponized in the DOJ, I'd like to know whether Governor DeSantis in the state of Florida has been cooperative in your effort to protect our schools.
I don't know the answer to the question that you're asking. We are trying to prevent violence and threats of violence. It's not only about schools. We have similar concerns with respect to election workers, with respect to hate crime, with respect to judges and police officers. This is a rising problem in the United States of threats of violence, and we are trying to prevent the violence from occurring.
Attorney General Garland, I appreciate it, and I am shocked and dismayed by the lack of concern by some of my colleagues on this committee. Last year, Attorney General Garland, as you pointed out, over 93,000 people died of overdose in America. Young people aged 15 to 24 saw a 48% increase. Earlier this year, I lost my nephew, Eli Weinstock, to an accidental overdose after he consumed a legal herbal supplement tainted with fentanyl. Last month, in response to the surge of overdoses caused by fentanyl and fake pills, the DEA issued its first public safety alert in 6 years and has ramped up enforcement efforts, resulting in the seizure of over 11.3 million pills and there were 810 arrests. In a Washington Post article entitled, "With Overdose Deaths Soaring, DEA Warns About Fentanyl Meth-Laced Pills," from September 27th, that I ask unanimous consent to submit for the record, Mr. Chairman.
Without objection.
In that article, it said that young people assume that a pill purchased online must be made in a reputable lab and must not be too dangerous. We are in the midst, according to DEA Administrator Milgram, we are in the midst of an overdose crisis, and the counterfeit pills are driving so much of it. Many of these counterfeit pills that alarm the DEA are being sold on social media sites, Snapchat, TikTok, Instagram, YouTube. Milgram said that the drug dealer isn't just standing on a street corner anymore, it's sitting in a pocket on your phone. Attorney General, what more should social media companies be doing to prevent young people from finding deadly drugs on their platform, and what more can you do about it?
Well, with respect to the latter question, what we can do about it, the DEA has intensified focus on this problem of fentanyl crossing the border from Mexico, made from precursor, which often come from the People's Republic of China. This is a very dangerous circumstance. The DEA much of the, I think the article that you're referring to comes from a press conference that the DEA administrator gave. A significant portion of these pills are lethal overdose with one pill. And this is an extraordinarily dangerous problem that we are putting our full attention to.
And Attorney General Garland, I assure you that there is strong, notwithstanding much of what else you'll hear today, strong bipartisan support in this Congress to combat the threats of fentanyl and rising overdoses. Finally, yesterday, the person who shot and killed 17 people at Marjorie Stoneman Douglas High School, injured 17 more, and traumatized my entire community, pleaded guilty in a Broward County courtroom. Many Parkland families strongly believe that gun companies must also be held responsible for the dangerous marketing of assault weapons. Unfortunately, the Protection of Lawful Commerce in Arms Act, known as PLACA, has blocked countless victims and surviving family members from their day in court. The law provides broad immunity against civil lawsuits unique to the gun industry. Unfortunately, the Department of Justice has a long history of intervening in civil cases filed by gun violence survivors to defend this law. The question is whether you believe, Attorney General Garland, that repealing PLACA to hold gun makers accountable for their products and the marketing of those products could improve gun safety in America.
So the President has already stated his opposition to that statute, but our obligation in the Justice Department is to defend the constitutionality of statutes that we can reasonably argue are constitutional. That's the position that the Justice Department takes, whether we like the statute or not. We defend the constitutionality of Congress's work.
The time of the
You
gentleman
support the
has
passage of the
expired.
John Lewis Voting Rights Act. I hope that you'll support.
Time of the gentleman has
PLACA. Thank
expired.
you.
At this time, we will take a very short 5-minute break. We will return immediately after the committee stands in recess.
Thanks for watching, and if you haven't already, please consider subscribing to our channel. And while you're at it, please leave us a comment. Thank you for watching.